Welcome to the Legally Speaking podcast. I'm your host, Rob Hanna. This week, I'm delighted to be joined by Éamon Chawke. Éamon graduated from the University of Cork with a first-class honours in law and attended the University of Oxford, where he completed his postgraduate diploma in intellectual property law and practice. Éamon is a partner at Briffa Solicitors, specialising in intellectual property, data protection, and commercial law. His practice strongly focuses on trademarks, branding strategy, commercial contracts, and problem solving. Prior to joining Briffa, Éamon was an associate at Simpson, Thatcher and Bartlett LLP and was a trainee solicitor at Matheson. So, a very big warm welcome, Éamon.
Hi Rob, great to be here. Thanks for having me.
It's a pleasure to have you on the show. And before we dive into all your amazing project experiences to date, we do have a customary icebreaker question here on the Legally Speaking podcast, which is, on the scale of 1 to 10, 10 being very real, what would you rate the hit TV series Suits in terms of its reality of the law, if you've seen it?
I have seen it, but I haven't seen it for a very, very long time, and I didn't watch it for very long. So based on my very sort of cloudy memory, I would rate it at about a 3, in the sense that it does sort of refer to basic legal things like documents and going to court or whatever, but almost everything else in terms of the execution and what people do every day is fantasy from what I can remember. So I don't know whether that will anger people or whether people will agree, but there you go.
I think the majority will agree, and I think you justified your 3 very well. So with that, we should move swiftly on to talk all about you. So to begin with, Éamon, do you mind telling our listeners a bit about your background and career journey?
Yes, absolutely. So I grew up and went to school and university in Ireland. And interestingly, or maybe not interestingly, I didn't always know that I wanted to be a solicitor. I didn't even always know that I wanted to study law. And actually, when I first finished secondary school, my application was for an arts degree in English, music, and the Irish language. I lasted in that course for about maybe 5 weeks before dropping out of university, taking a year to decide what I wanted to do, and I ultimately decided that I would go and do a law degree. Fast forward sort of 5 or 6 years, I'd done 2 degrees in UCC in Cork in Ireland, and I decided that I was going to be a solicitor, and I qualified as a solicitor with one of the really big commercial law firms in Dublin, in Ireland. And the big focus of those big firms is on big commercial law. So I did seats in things like banking and finance and, investment funds and financial institutions. And so by the time I qualified, that was where all my experience lay. And so when I moved to London and worked for a big US firm, that was the area that I went into. However, I sort of decided fairly soon after qualification that even though this was, the firms were great and the opportunities were great and the money was great and there was lots about that life and that practice area to recommend it, it wasn't where my passion lay. And so I had a really sort of honest conversation with myself about what I actually wanted to be doing every day. And I thought back to the areas that I really enjoyed in university, the areas that I enjoyed in law school, and the part of my training contract that I really enjoyed, which was the first half of my first seat, which was being in the IP group of the litigation department in Matheson in Dublin, the firm I trained at. And I really enjoyed the people I worked with. I really enjoyed the subject matter. And so I decided I'm going to make the big switch to IP. Which wasn't easy because sort of banking, finance, which was where all of my recent knowledge and experience lay, and trying to switch into IP, which is quite a different area, was challenging enough. But I applied to a firm, Briffa, the firm I now work for and I'm a partner in. And luckily, I was given a shot by the then managing partner, Margaret Briffa. And yeah, even though I had very little experience or knowledge of IP, she gave me a shot. I came in, learned a lot really, really quickly in the first sort of 6 months to a year, went to Oxford, did the IP diploma, and now for the last almost decade, it'll be 10 years next year, I've been doing intellectual property day in, day out, every day, and I absolutely love it. So that's my journey. It was a circuitous route, but that's it in a nutshell.
No, and I really appreciate that. And a lot of our listeners will get value from that. And I hope that inspires other people. I think the key lesson is you had that honest conversation with yourself, because I'm really passionate about people really having a fulfilling legal career and not being stuck in something that ultimately may not be giving them that fulfillment. So that fact you're actually confident enough, brave enough to do that, to then move into an area of law where your true passion lies and made a success of it, that's fantastic. So really appreciate sharing that. Hopefully other people listening in will get some value from that too. So you mentioned, obviously, you've specialized in intellectual property coming up to 10 years. Maybe for people who are less familiar, could you maybe give a bit of an explanation of sort of IP law, bit of data protection and commercial as well, just very high level so people have a greater understanding?
Yeah, sure. So intellectual property refers to property or assets that relate to the mind. But IP, sort of on its own, doesn't really mean anything else beyond that high level conceptual umbrella term. Rather, intellectual property refers to a set of individual rights or assets that sit underneath that umbrella term. And each of those things protect different types of subject matter. So trademarks, broadly speaking, protect brands. Copyright protects creative works. Design rights protect the appearance of products. Patents protect inventive products or inventive processes. And so intellectual property law is all about understanding how you protect those different types of things through some sort of monopoly. Data protection then is about protecting information that relates to people. It's sort of related to privacy law, and it's related to the law of confidence or the law that protects confidential information. But when we talk about data protection, we're sort of talking specifically about the regulations and rules and laws that are in place to enable people to control what happens with their personal data when it goes out there into the world. And obviously, that whole exercise and giving people the power to control their personal data became way more important over the last, say, 30 years with the internet and so much information being publicly accessible online. And that's what catalyzed the GDPR, which was the European law that came in and updated the old data protection directive to make sure that people had, that law had much more teeth. So that's data protection. And then commercial law is a very sort of broad, woolly term, which basically refers to the law relating to businesses and how businesses interact with each other in commerce or in trade. So it's everything from the law regulating the sale of goods and the supply of services and agency law and bits of contract law, commercial contract law, and even intellectual property would be sort of part of commercial law. So yeah, broadly speaking, that's my bag.
Yeah, no, and it's a really interesting bag, and you're right. And again, with my legal recruiting hat on, it's a good point you mentioned, because sometimes in commercial departments, IP will sit in that within certain firms, and some in their own or have their own departments themselves. So I think it's a really good general high-level overview. Look, you've worked across some interesting sectors, you've worked some interesting professions, authors, architects, photographers, you name it. Is there a memorable case that stands out to you that you can share with us?
There are loads of memorable cases. I don't know what I can or should share. One that actually stands out from my early days at Briffa was I was acting for a quite a small business in West London, and he had a hairdressing salon. Quite a small business, but he'd been there for a really, really long time, really well-established brand and reputation. And in addition to providing hairdressing services, hair salon services, he sold his own brand shampoo and conditioner, and I think maybe a couple of other cosmetics, but the shampoo was sort of the main thing. And then this really big foreign cosmetics company was trying to enter into the UK market and was filing an application for a trademark which was very, very similar, almost identical visually and phonetically to my client's brand name. And they essentially assumed that they would be able to bully him into sort of changing his brand name or just letting them come in. And he wasn't really having any of it. He said, I have trademark protection for my salon and I have trademark protection for shampoo, which sits in the same trademark classification as cosmetics. So these guys who wanted to come into the UK market and effectively use his brand name would clearly have been infringing. We had good grounds to prevent them. We had good grounds to oppose their trademark registration. And the reason it's a sort of a memorable case is we effectively sold our trademark and our goodwill and our brand to this other company for a huge sum of money for this guy. And the reason I think it's a useful example is that it's a reminder, even to very, very small businesses, about how important it is to protect, sort of know what your rights are, number one, and what you have that's of value, even in a very small business. In this case, your brand name, your reputation, your goodwill. To know what to do to protect it, file a trademark application, and to know what to do when someone encroaches on your space or does something that might damage your trading reputation or your goodwill, and to know how to sort of stand up for your rights and exercise your rights. And it's a really good illustration of how these little trademarks are actually really, really powerful monopolies. And, this guy was able to rebrand, and he was able to invest all that money in his business and do whatever he wanted. When in lots of other situations, brand bullying happens all the time, where big businesses come in and effectively just outspend smaller companies or individuals. So yeah, that was a nice thing to be able to work on and to get a good outcome for the client.
And that's a lovely story, isn't it? It's sort of almost with a David and Goliath there. And it's a really good lesson in terms of, I always say to people with businesses or creators, like, don't build on quicksand. Get the infrastructure in place. And of course, a large part of that is your IP, particularly now the world we live in with onlines and everything involved. So yeah, I really like that story that, maybe you don't have necessarily the deep pockets in place, but if you put the infrastructure in place, you can still provide a level protection, and then potentially get a payday. And it sounds like a great result for your client there. So really good lesson. Thanks for sharing. Let's talk about partnership. What does a typical day look like for you in a boutique firm as well, such as Privet?
Oh, I mean, it's such a cliche, but the only constant is change,
Yeah.
or certainly variety. There's no 2 days in my job are now the same. And I love that. It's one of the ways in which my job now is completely different to my job working as a more junior solicitor in a very large firm, where then my day would be working on a very, very small number of very large cases or transactions. So you spend sort of every day and many days drafting witness statements or drafting proceedings or reviewing 200-page facilities agreements or intercreditor agreements, and you become that's can be interesting too, and you become very technically good at that because you do that one thing over and over again, and you become a very skilled advisor, and you learn your craft very well. As a partner in a small firm, it's different in two ways. Number one, at least 50% of my time is not spent doing anything legal. I spend my time going to finance meetings, going to partners meetings, thinking about technology that we want to invest in, thinking about how we can improve our training, thinking about how we can make life better for our lawyers, thinking about how we can make our service better for our clients, thinking about our positioning in the market. The legal market is quite competitive, and even in a niche area like IP, you have to be constantly thinking about how you're doing. You have to be self-critical. So I spent a lot of my time doing all of that and dealing with all that crushing imposter syndrome. And the other 50% of the time I spend doing the other stuff that I really like, which is dealing with clients and thinking about IP and working about IP. And as I said earlier, I love the subject area. I really, really enjoy thinking about trademark issues, design right issues, copyright issues, even data protection, which bores some people to tears. I do actually find, quite interesting. It's if you have to sort of solve a problem. But again, because I'm working in a boutique firm with lots of smaller clients rather than a large firm with a small number of larger clients, I sort of bounce around to lots of different clients, lots of different matters, some of whom I'm dealing with myself. But in lots of cases, I'm supervising more junior lawyers. So I'm sort of dipping in and out of the different matters they're on, discussing their strategies with them, reviewing work that they've done to make sure that we're keeping all the plates spinning. So yeah, variety is probably the word that I would use to describe an average day at Briffa.
And well justified as well. It has to be said, and that's an important point. With partnership, obviously, you have salary partner, equity partner, variations of partner, but really getting into that role is you are more than just practicing law. There, you're running a business in many respects, and you're looking across everything, like you said, anything from sort of people management to training to technology, which we're going to talk about at the moment, to just general business solutions and driving the firm forward. Because let's be real, we're in a competitive world, and other people will eat your lunch if you're not at the forefront of being sort of innovative, being creative, and moving forwards, because that's just the nature of the beast that we're in. So what I really admire about Brickra as a business, that you are forward thinking, you do embrace technology, you do think of innovative ways of doing things, and undoubtedly that's why you've been super successful in yourself and your own career. So let's go back to 2019, because Brickra recognized the need to innovate and improve its systems. Can you tell us about Britta's journey in leveraging technology to enhance its operations and to help drive growth?
Yeah, sure. So if you look at sort of the bigger picture of Briffa, the firm was started in 1995, so we'll be 30 next year, 2025. And probably for the first sort of, 2 decades up to 2015, or maybe just shortly after that, Briffa operated as a really lean, scrappy startup, and very intentionally so, very much by choice. And we sort of adapted to technology as we went along, in the same way that every firm did, but without making any huge investment in sort of new tech. And that was a perfectly reasonable way for a small boutique IP firm to behave. And we were all reacting to sort of new technological things that were happening in those first 2 decades. In 95, Amazon was new, eBay was new, Google wouldn't come along for another 3 or 4 years. Facebook and all the big social media platforms wouldn't come along for another sort of 10 or 15 years. So over the course of that first 2 decades, some things were changing, and we were changing the way we did our practice, because infringement was now happening online and you had to interact with these new platforms. But in terms of the internal mechanics of the business, not a lot had changed, except for the fact that we were maybe using computers more often. But yeah, in 2019, luckily, given that COVID would happen in March the following year, we sort of sat down and we thought strategically about the current state of tech, and we made very sort of specific decisions about investments that we wanted to make in new tech to get ourselves on a track moving forward. And one of the first sort of key decisions that we made was that we were going to move away from physical servers and into the cloud. With an eye towards remote working, and being a bit more forward thinking and forward looking when it came to agile working generally, but obviously having no idea that within 6 months of having made that decision, everyone in the world would be working from home pretty much.
Yeah.
So the first thing we had to do was go and find a cloud service provider to manage all of our data securely and all the rest of it. And we did a lot of research. We auditioned a few people, we demoed a few people, and we ultimately landed on Clio, who we now use. So that was the first sort of key step in our journey. Subsequent to that, we did other things in conjunction with COVID the following March and the year after that, and year and a half after that. So we sort of got rid of all PCs and replaced everyone with laptops to facilitate agile working. We got rid of all telephones and replaced everything with Teams, which redirects to everyone's mobiles. Very much geared towards cloud-based mobile technology. So all of that happened over the last couple of years. That was the internal stuff. Externally, we did a full sort of rebrand and revamp of our website, and we put a lot more investment into the website, and in particular into sort of SEO to drive inquiries through our website. A lot of our work comes through inquiries from small businesses, growing businesses, individuals. So that's been really successful. And to drive those inquiries, we put a lot of effort into generating content for the website. So we write blogs and we do other things like that. And then I guess most recently, sort of between the second half of last year and the beginning of this year, we've been driving very much towards investment in AI and looking towards what the legal landscape is going to look like in the next sort of couple of years. So we're looking at yeah, we've sort of plans in the pipeline to invest in AI tools to make our service even more efficient. So yeah, that's it, sort of in a nutshell. But yeah,
Well, it's a lot actually, and it's really great to hear that because typically when we think about lawyers, they think about risk, right? And they think about what is the risk with doing this, and this. And one thing I want to talk a little bit more about is technology, because I think it's a huge risk to not pay attention to technology. And obviously, you mentioned AI as well, and I want to go through sort of Britha's decision making process, because obviously purchasing technology, there's sort of risk attachment to that, and also there's sort of, am I getting the best thing? So when you chose to sort of adopt Clio, I think it was in 2020, who obviously proud sponsor of our show as well, using both Clio Grow and Clio Manage for client onboarding and practice management software, what were the key factors specifically for Britha that led you to choose that particular tech solution, and what advice would you have for other firms who might be thinking about a legal tech solution?
Yeah, probably the first thing that struck me was they were everywhere. I kept seeing Clio adverts everywhere. So whatever they were doing on LinkedIn or wherever else I was reading, the algorithms were doing their job. They targeted me in the way that they were supposed to. So obviously they were sort of well invested in promotion, which is good. The other thing, which was a really key distinguishing point, was they were recommended by the Law Society of England and Wales, and I think subsequently they got similar recommendations or certifications from the Law Society in Scotland. I think the Law Society in maybe Australia or New Zealand. They really worked at doing their research, looking at what the regulatory requirements were in different jurisdictions, and making sure that their product was going to be fit for purpose in these various different areas. So that was obviously important. As a regulated firm, we have to go through audits. We have to make sure that we're tracking our client money correctly, that we're doing all the things that we're supposed to be doing. So that was important. Looking more at the sort of tech side of things in comparison to some of the other platforms that we saw, my sort of personal view was that Clio was very intuitive. It felt modern. It felt easy to use. It was very much sort of drag and drop, click here. Someone had thought through the process. And it's a bit like when you use an iPhone for the first time. You never need to read an instruction manual because it's just intuitive. That swipe of the finger or click of the finger is, it does what you think it's going to do. And it's all very easy to use. I sort of felt like that with Clio. Whereas some of the older software packages I felt were sort of a bit clunky. They felt a bit Windows 95e, Windows 98e.
Sure.
That's not necessarily, that doesn't mean that they can't do the job perfectly well. And in terms of functionality, maybe that's fine. Maybe they're even better. I didn't know. But certainly in terms of usability and ease of usability and getting all of our lawyers to transition into using a completely new platform, I felt that was important, that it would be something that we would easily adopt. And then the other thing is the people we were dealing with. Customer service was really, really good. From the very beginning, it felt like you send an email, you pick up the phone, you get to speak to someone. They're really, really responsive. And they've loads of ways you can contact them. They've got the little chat thing in the corner, got telephone, got the email, got the whatever. And, we all deal with service providers, whether it's your bank or whether it's the tax authority or the local council or whatever it is. We all know what it feels like to be stuck on a phone listening to hold music for 15 minutes, not being able to get in touch with your relationship manager when you need to get something really important done. It's infuriating. So feeling like you're sort of in it with someone who gets that you need a quick response is really important. And sort of connected to that, it felt to us that Clio was a bit of a scrappy startup in the same way that we were, and they really listened to us in terms of what we needed, including in particular when we raised an issue with them that arose in relation to our Irish Law Society audit, where there was a sort of a gap in a regulatory issue, which I won't bore you with. They picked up the baton, we had a meeting with them, and we worked with the developers to actually build a new thing that was required for this specific thing that arose out of our audit. And for most service providers, particularly for a small firm, we're not we're not their biggest client, right? But for most other service providers, they just say, "Oh, sorry, computer says no. This, the software has been made available to you on an as-is basis. If it doesn't suit you, sort of sorry, but you're signed up now." We could have walked away from Clio and they could have said, yeah, we can't facilitate you and you're a small client and there's other areas where we want to put our development time and budget. But no, they sort of cared enough to pick it up, deal with it, and they fixed it in like 8 weeks, which is really, really, as you may know, is a really, really quick turnaround in terms of software development. So yeah, and since then we've been involved in various different ways and at various different levels in sort of participating in the direction of how the Clio platform develops and evolves, and that feels good to be working with someone who is adapting to what we need and to what the market needs. So yeah, those are just some of the reasons that we sort of went with them, and that's
and I think there's some really good lessons in there for other law firms who might be thinking about, new technology. Number one is obviously, is the product fit for purpose now? It may not be, like you referenced some of these older products, you do get the impression that it's sort of where is fit for purpose now. Then you talked a lot about sort of, being able to communicate clearly and be listened to and feel like a valued customer. I think, again, you want to make sure you've got that good connection and communication and relationship. And then also when inevitably problems arise, no business is perfect, no person is perfect. And actually problems are good because it means it's covering new territory. So it means you're improving. So the fact that then you can get responses to that. So, whatever provider you use, if there's an issue, then making sure if they're being up to the mark and actually solving that and quickly, then that's a really good supplier to you to definitely keep in your arsenal. Because even with us, when we're thinking about technology or using different things, I'm really pleased when people get on the ball and change it. But I think there's some really good lessons in that.
Today's episode is brought to you by Clio Payments, the ultimate solutions for law firms looking to streamline their billing and payments. Clio Payments, available in the UK, has updated its pricing for pay-by-bank transfers, allowing you to accept these transfers for free. Yes, that's right, 0 fees on bank transfers. And here's the cherry on top. Until May 31st, 2024, Clio is offering new customers an incredible 90 days of free card processing on card payments. With Clio Payments, which is included in Clio Managed subscriptions, you can handle all your billing, payments, and collections seamlessly right within the Clio platform. No more switching between systems, no more headaches, just pure efficiency. Record your time, generate and send bills, accept payments, and automate reminders and reconcile payments, all in one place. Even after the 90 days, you'll continue to enjoy free pay-by-bank transfers. As for card payments, they'll be charged at standard rates. Don't miss out on this incredible offer to save money and gain more time for what truly matters. Visit clio.com/UK/payments today to learn more and start simplifying your law firm billing and payments process. That's clio.com, clio.com/UK/payments. Offer ends 31st of May 2024. Terms and conditions apply. Now back to the show.
Okay, I want to talk about generally cloud-based technology because this really shouldn't be a new concept. We are in 2024, but I still get the impression certain law firms are quite paper heavy, are quite still very much focused on traditional methods. How has cloud-based technology, particularly, obviously I know you use Clio, but helped Griffith stay competitive, particularly in this rapid changing legal landscape where no 2 days are going to be the same and it's just going to keep getting quicker and quicker and quicker?
Yeah, I mean, in every conceivable way is the short answer. I mean, you can look at it from the perspective of, say, us internally or, management, pillar 1. You look at it from the perspective of our employees, pillar 2, and from the perspective of clients, pillar 3. So if you look at issue 1, how we deal with things, having a cloud-based system just makes everything more agile. We can access things at work, we can access things from home. We don't have to deal with the risk of a physical server. We don't have to deal with the sort of physical clunkiness of having to deal with paper documents rather than documents that we can easily access online. Everything about our management job, our supervision, all of our responsibilities are made easier by the fact that we can deal with a cloud-based system. If you look at it, and sorry, I suppose to add to sort of pillar 1 and our perspective as managers and as partners, our business would have come to a complete and total grinding halt during COVID if we didn't have a system in place whereby we could work remotely and we could access things from a cloud-based system. So from a management perspective, and you're thinking about the survival of our business, that was really important. So that was one way in which it made a difference. Looking at it from the perspective of the people who provide legal services on our behalf, our lawyers and our other staff, in exactly the same way, they wouldn't have been able to do their jobs during COVID if we couldn't facilitate them working remotely. But also just thinking about their health, their physical and mental health, their happiness, the joy that they get out of their job. I hope they get at least some joy. The fact that we have all these technological cloud-based systems in place means that they can easily work from home. They can easily work from abroad. They can avail of our unlimited annual leave policy. Like we really try to have a good culture of don't live and die here. This is not, this is a job. This is not your whole life. You're a much better, happier, more productive lawyer if you feel like you can find a good balance in your life. And part of finding that good balance is taking downtime when you need to take it, taking time with your family when you need to take it, taking a day off or taking a holiday when you need to take it. They do better work. They're more productive, which is good for us and good for them and good for clients. And it would be really, really difficult for us to allow them to take holidays whenever they want, to work from abroad whenever they want, to be really flexible and have that family life if all of their stuff is here. If you have a physical computer here, if you have physical documents here, if you have physical everything here, either you have to be here as well, or you have to lug it all around in a suitcase, neither of which are good. And then lastly, from the client's perspective, we're just better. We're just more efficient with a cloud-based system. So we provide a quicker and a more efficient service. We can allow them to access documents and things through platforms. We can facilitate e-signature of documents. Everything about the service is better for clients with cloud software as well.
Yeah, and I want to talk about speed in a little bit more detail, but I just want to talk about, just some obvious benefits there when it comes to helping flexible working arrangements, helping, families who may be raising young families who can work flexibly due to the benefit of having cloud, remote working. And like I say, just continuously being able to sort of have access to your tools and your toolbox wherever you are in the world is just an absolute game changer. Like you can't just be running from, I don't know, I'm off to St. Lucia currently, and I can't be running back to the office to try and grab something if I'm in a different part of the world. So really good point. Okay, let's talk about your Law Gazette comments, because you say taking the middle ground, what tech-savvy clients expect of us now is that level of speed, which I know you referred to. They will not wait 2 or 3 days for you to come back to them. So in what ways has implementing the likes of a Clio really assisted Britva in keeping up with client demands and nowadays expectations?
Yeah, I mean, as I said earlier, having a cloud-based practice management system has made us quicker and more efficient, just because we can access documents more easily. We can send documents more easily. We can you don't if you're away from the office, for example, you don't have to wait until the next day before you can do something. So there's that level of sort of speed and efficiency just comes with having a good system at the center of your business. In that article, I think I was sort of referring specifically to generative AI and how quickly things are going to change in terms of contract drafting and trademark searching, and something that maybe now and certainly last year you could reasonably, with a straight face, say to a client, this is going to cost however many £100 or £1,000 and it's going to take me 4 days. Now, and certainly in the very near future, clients just won't accept that anymore, because they'll say, well, no, there's a piece of software that can review that contract or summarize that case or do those searches in lightning speed. Clients' expectations will change, just like when technology advanced in the past. Before everybody was using computers, you could legitimately take, I don't know, a week or 2 weeks to review a contract and send your revisions back in the post. Nobody would accept that now. They expect you to turn things around in a couple of days. So I think the rate of technological change means that we must start using these tools, implementing them into our practices to meet what would be clients' legitimate and reasonable expectations in the very, very near future.
Yeah, and it's the great word reasonable that lawyers use, but it's so true, isn't it? I think it's a reason. It's not a sort of unheard of or outrageous request now. that is the scale of the game, and the velocity and speed of which technology is coming in. The law firms who refuse to kind of be current and forward thinking, will be behind the curve. And it's all about, as you know, staying ahead of the curve. And, let's talk about BRIFA, because it aims to make legal services more accessible to a broad population, which I think we're all in support of. So how does BRIFA ensure its legal services are affordable and transparent for clients? And how does technology ultimately contribute to achieving this goal?
Yeah, it's a good question. I suppose one of our sort of core ideas, or something that has always sort of been at the center of BRIFA, is that we're a firm that services people at the end of the legal market who would have traditionally been priced out, and particularly in IP. I think it used to be called industrial property as opposed to intellectual property, and there was a sense that IP and patents in particular were very much for big companies, big pharmaceutical companies, big tech companies, whatever. And if you were a small creative company, that wasn't for you. So we wanted to sort of confound that idea by making advice and access to legal services available. The first and most obvious way is give information away for free, at least some information. That doesn't mean you have to give advice away for free or that you have to work for free, but hear people out. Give people consultations, try to arm them with as much information as you can so that they can sort of help themselves and get themselves up on their feet, get the business going, and get those early protections in place if possible. And then when that business is trading, if you've treated them well and you've developed a good relationship with them, they will come back to you, hopefully, and then you'll become their trusted legal advisor. You build that relationship and then you get paid for your advice. That's the first way. The second way is another sort of really obvious one, or at least it's obvious now. It wasn't always obvious. Transparency on cost. Traditionally, law firms charged on the clock. You got an hourly rate, and it meant that the client was in a really weak position. Very difficult to budget, but no one was operating in any other way than charging on the clock. So you didn't really have an alternative if you wanted to access legal services. So we try to stick to fixed fees as much as possible. So you say that letter, that contract, that filing, whatever it is, absent something really unexpected, we'll stick to what we said that thing was going to cost. That helps people to budget. And at least if it may still be expensive, but you can put it into your budget along with all your other costs, like your rent and your insurance and your whatever. How does technology help you to do those things? It just makes the whole business more efficient. We can look at our resources and we can say, okay, if this is how much billable time everyone is doing and this is how much admin time we need, we can set aside this time for BD, for outreach, for whatever you want to call it. So our lawyers can hit their targets and they can work profitably by providing paid legal services and still have time to go to universities, to go to incubators, to go to trade associations and professional bodies, and sometimes just to go to individual businesses and give talks and workshops and seminars on IP, to give people free meetings and consultations, to be as supportive as we can be. And that is effectively our investment in marketing. We do some investment in marketing. We invest in things like SEO, but we don't advertise in newspapers. We don't advertise in tube stations or on the side of a bus. That our quote unquote spending on getting the word out is by our time and giving people that advice. And sometimes people do help themselves and we never hear from them again. And sometimes we do, but years later, or we don't hear from them, but we hear from someone they met down the pub, and you get a sort of a referral from an unexpected place. But yeah, I think the ethos is, if you sort of put it out there, give people the information, develop a name for yourself as someone with a bit of integrity, transparency, the work does come back. And yeah, technology helps that by just making us more efficient.
Yeah, you gave some really good examples there about how it can help with your growth, improving your firm efficiency and ultimately obviously increasing revenue, freeing up time. So many different ways that it can ultimately overall improve your firm and your business. And you're right, I strongly believe in putting yourself out there and, that thought leadership and leading with value. I always say the web is really quite far and wide. You never quite know where that, like you say, out of the blue referral coming from. And, someone did a great piece of work and you stay top of mind from that piece of work that you did from way back where. Okay, we've touched a little bit about AI. Of course, I can't do a recording now without talking about AI. It is just so prevalent. So in your article titled AI versus Copyright, you discuss AI and the platform ChatGPT. I think I've heard of that one. From a copyright and intellectual property perspective, how does ChatGPT raise copyright issues? And I know this is a broad question, so you can be as succinct as you like.
Yeah. In other words, don't talk for the next hour about copyright.
I know that is an hour-long question in itself.
I mean, put very simply, lots of these large language, in fact, all of these large language models are trained on some sort of data set. Some of them are open data set. They're just mining and scraping data from the open internet, and some of them are closed. If they're closed, you've some, if the data set is fixed and you know what data your model is trained on, you have some possibility of sorting out all of the underlying IP issues, because you can get licenses or assignments to make sure that you either own the copyright in the underlying data, or you have a license, you've permission to use it. If, like ChatGPT, you're just scraping open, the open internet, aside from the increased likelihood that the quality of your output will be bad because you haven't tested the quality of the underlying data, and aside from things like data protection issues and other issues that might arise, one problem that you have is you are likely mining and scraping and reproducing copyright works, quote unquote, whether it's a literary work, whether it's an artistic work, a recording, whatever it is. And ChatGPT is just one example, and the output for ChatGPT is literary. But we know now that there are loads of other platforms and websites and models that produce artistic content and video content and all the rest of it. And what all of these things are doing are effectively acts restricted by copyright, which is, I suppose that's the argument. Are you taking a substantial part of the underlying work, and are you reproducing it? Is copyright infringed or not? And that's what we have to grapple with. That's what we have to deal with as we we in the UK, but also other countries around the world, as you try to regulate these platforms, both for the people developing them and for the people deploying them and using them. You have to think about how you address that. How do you protect creatives, the copyright owners, IP owners, and how do you also deal with the commercial reality that the internet is here to stay, the data on the internet is here to stay, and people are going to be using this technology. How do you regulate it? How do you allow people to benefit from it, while also dealing with the IP issues? So yeah, there isn't really a short or succinct answer. Sorry.
No,
Sorry, Rob.
it's true. No, it's very true. I think you raised a good point about this is a global issue. We live in the world where the internet and everything is being more connected than ever, and AI is going to bring more people connected. But like you say, so it's not as straightforward. You're dealing with multi-jurisdictional different laws and a whole host of different things, which again keep you rather busy. Excited from a practice point of view, but definitely not a straightforward answer. Okay, what are some of the, quickly before we look to close, some of the emerging trends or technologies? Obviously, I know we touched on AI, but in the legal tech space, you find particularly exciting or promising looking forwards?
In the legal tech space, yeah, I think a lot of the things that are emerging now are going to relate to, or do relate to, some sort of machine learning or some sort of generative AI. The tools that we're looking at the moment are around contract drafting and contract reviewing, which is again, it's really nerdy, but it's such interesting tech to think that you can say to an AI tool, review this 60-page contract and summarize it in a couple of hundred words, or review this grant clause, this license clause, and make it pro-licensee or pro-licensor, and it's based on huge volumes of data of other similar clauses that it's read. And it can understand what is or isn't pro-licensee or pro-licensor. That genuinely is interesting if you sort of think about how much data that involves. So that's really interesting. In a similar vein, for things like case law, having AI tools that can take a 50, 100-page judgment and distill it down into principles is itself really impressive in terms of an output from a piece of technology. But then sort of horizon gazing and thinking about what that could mean for the future, particularly in an IP context, is incredibly interesting. If you do that for one case, what do you do if you do it for 100,000 cases? And you say, okay, can we now predict the outcome in a trademark infringement case or a copyright infringement case or a design infringement cases based on these 100 previous judgments? That's interesting in any area of law, But I guess if you were looking at a sort of tax law case or a company law case, it's a little bit more black and white. It's a little bit more sort of predictable. Land law, areas like that. Whereas I think with trademarks, you're very often looking at two images and forming a subjective view on whether they're confusingly similar or not. Or you're looking at two pieces of art and you're taking a view on whether artwork A has taken and incorporated a substantial part of artwork B, and what on earth does substantial part mean? It's because we know in law that it's qualitative and not quantitative, or at least it's not exclusively quantitative. It's a combination of qualitative and quantitative. So that sort of potential for a piece of technology to read a huge amount of data based on decisions that have been handed down by judgments in the past and predict the outcome of cases moves you closer and closer towards essentially AI courts or AI judgments, or at least preliminary judgments, or AI mediators, AI arbitrators, predictors of the outcome of cases, which facilitates something I'm really interested in, which is just better access to justice, particularly for smaller businesses and individuals who are effectively priced out of, even with things like the IPEC, which is really useful. It's a court with cost caps specifically for IP. But even then, lots of small businesses and individuals are effectively don't have access to enforce their rights. And if you had technology effectively predicting the outcome of cases, it could facilitate settlement, it could facilitate mediation, it could help people to enforce their rights much better. So yeah, again, not a short or succinct answer, apologies, but those are the things that I think are coming that I find interesting.
Yeah, and who would have thought, my late grandfather, who ran his own law firm, started in 1950, AI courts, he would probably say to me, what on earth are you talking about, laddie? But that is the world that we live in, and it's going in that direction, and I'm excited and I'm here for it. So finally, what would be one quick piece of advice you would give to law firms looking to embrace technology and innovation within their practice?
One piece of advice: start now, jump in. Obviously, It's important to do your research, as all lawyers know. You have to do your due diligence, you have to read your T's and C's, you have to be clear about what you're buying, look at the termination provision, make sure you can get out if things go wrong, like all that kind of stuff. And work with the right people, know who you're dealing with. Do they share your ethos? Are they, like Clio, are they going to be responsive? Are they going to work with you? But ultimately, once you've done that, start. Don't wait. Particularly now, the rate of change has increased rapidly. And, what everyone is saying is it's not that lawyers or law firms are going to be replaced by AI. They're going to be replaced by other law firms, other lawyers who are using AI, because they're going to be way more efficient, they're going to be way more responsive, they're going to be more profitable, and you're just going to get priced out or outpaced. So yeah, that's what I would say to people. The rate of change is fast now. You've got to read a lot. We don't have the luxury of saying, I'm not into tech, I'm not into AI, I'm not into any of that. You have to be reading the Gazette, you have to be reading articles, try to educate yourself as much as possible about what's happening. Think about how you can use these technologies and tools in your business and lean in.
Yeah, so true. And that's why we produce a show. We want people to keep picked up on people's wisdom and what they're doing, because it's as simple as this, isn't it? Either invest now or pay a lot more later. That is kind of the option you have, and I think now is the absolute opportune time. So, Éamon, this has been a fascinating discussion, as I knew it was going to be. I always like talking about things tech and careers, and you've done fantastic well throughout your career journey, and indeed, Britain's journey has been impressive too. So, if people want to find out more, where can they go to find out more? If there's any particular social media handles or website links, feel free to shout them out. We'll also share them with this episode for you too.
Briffa.com is the best place to start, or just Google Briffa Solicitors, Briffa IP, Briffa Law. I think we're the only show in town. And similarly for social media, if you search Briffa Law, Briffa Legal, or even just Briffa, you'll find us really quickly. We're on Instagram, Twitter, Facebook, all the biggies.
All the biggies, and you're there, and you're myself as on LinkedIn as well as Éamon Chawke, so people can find you there. And Éamon, thank you so much once again. It's been a real pleasure having you on the show. From all of us on Legally Speaking podcast, wishing you lots of continued success with your career and future pursuits. But for now, over and out.
Thank you for listening to this week's episode. If you like the content here, why not check out our world-leading content and collaboration hub, the Legally Speaking Club, over on Discord. Go to our website, www.legallyspeakingpodcast.com, for the link to join our community there. Over and out.